cross-examine him.
Yes, Mr. Robinson, let me talk to you a little bit about Defendant's Exhibit 84, your curriculum vitae, sir, if I may. You indicated that you've been as a forensic consultant since September 23rd, 2010. Is that right?
Yes, sir.
That's your own business. Is that correct?
Yes, sir.
Okay. And prior to that, you worked at the crime lab as director of the Atlanta Police Department. Is that what you indicated?
Yes, sir.
And you basically were in that position from May the 1st, 08 till September of 2010. Is that correct, sir?
Yes, sir.
And prior to that, you worked at the GBI crime lab from 98 to 2008. Is that correct, sir?
Yes, sir.
And now, as far as I understand, I've gone through all this. This curriculum vitae indicates basically your level of experience and training. Am I correct about that?
Yes, sir.
And on this, you indicated you had specialized training, technical and specialized training. Is that right, sir?
Yes, sir.
And on this particular exhibit here, your curriculum vitae, there's not any indication under that technical and specialized training that you've had any of that sort of training since 2007, right?
Correct.
So really from 2007 until 2015, you've had none of that additional training, right?
Correct.
But basically when you were with the crime lab, you had training on a regular basis, is that right?
Correct.
And that was to make sure that you kept up to speed with all the particular matters that were going on in your field. Is that right, sir?
Yes, sir.
And you did that, and they insisted that you have that kind of training in order to maintain your certification. Is that fair to say?
Yes, sir.
Okay. And so basically since of 2007, you've had no additional training in these areas, technical or specialized training. Is that right?
I do take proficiency tests every year, but you're correct. No specialized training.
Okay. I didn't ask you about tests. You haven't had any additional training, right?
Correct.
Okay. And you haven't had any additional training to keep yourself abreast of the field. Is that correct, sir?
I do read, but no, sir, I have not taken any specialized training.
That's right. And the matters, the tours and briefings and seminars of the different firearms areas, plants and so forth, you did those basically, the last one that you went to on some sort of seminar or whatever was 2008, 2009. Is that correct, sir?
Correct.
So you've had no additional matters like that since that time. Is that right?
Correct.
Okay. Now, in addition, as far as your matters here, sir, you've indicated that you were working with the City of Atlanta Police Department, right?
Yes, sir.
And you were the director of the City of Atlanta Police Department, right?
Yes, sir.
And when you were questioned on direct examination, you didn't inform the jury that you were terminated, fired from your job at the City of Atlanta Police Department. Isn't that correct, sir?
That's correct.
And you were terminated in September of 2010. Is that right, sir?
Correct.
And basically, you were given a matter about that to where they terminated you because they had grave concerns about your unethical decision regarding illegal purchases.
I object. As far as he can ask him what happened, as far as what is hearsay, we did the same thing with Officer Tony Howard, but they wouldn't let me get into it. So it's the same exact thing. He can ask him and let him answer his why.
I'm asking you. That's what I'm doing.
But he's reading from something that could be hearsay. We don't know.
The objection's over.
You were terminated because they had grave concerns about your unethical decisions regarding illegal purchases and reckless disregard for following proper procedures and protocols in other areas mentioned in the letters that you received. Is that correct, sir?
That's a discovery violation. We talked about it. What he gonna read about it for? It's a reciprocal discovery violation. We went over this before the jury come out. What is this?
Honor?
He's reading off something that didn't even admit discovery before discovery got in here. If I had to close my discovery, he had to close here too. He come in almost at the end of the trial, come up out of nowhere with this man.
Overruling the objection.
Well, I'd like to state for the record, Judge, you being advised and present, you already stated before that he couldn't use nothing because of reciprocal discovery. He can ask him any question as far as he want to ask him. Now, he hadn't lied to him. Now, if he lied to him and said he didn't have him, he can go into it. Now, if you want to do this, he'll go and send the jury home and send me to death row because this is becoming absurd what y'all doing in here.
Absolutely.
For the record, a continuing objection.
And you were terminated because it was was their opinion you lacked the maturity and skill set to be trusted as a criminalist manager of the crime lab. Isn't that correct, sir?
Yes, sir.
And also, it was their concern that your actions and poor decisions may compromise the integrity.
I will object, Your Honor. You gave me this expert. You didn't tell me nothing about this. So what you gonna let it come in here for? You told it wasn't gonna be no. You the one gave it to me, and you said you weren't gonna let it in, but you're doing it.
Have a seat. Objections overruled. Continue.
They terminated because they had concerns about your actions and poor decisions may compromise the integrity of the good work of the crime lab as well as the Atlanta Police Department. Is that correct, sir?
Yes, sir.
And for that reason, basically, you were recommended for separation from the employment from the Atlanta Police Department. Is that correct, sir?
Yes, sir.
And that's when you went into consulting on your own, right?
Correct, and I sued the city for wrongful termination. On July of the same year that I got fired, I had outstanding as high as you could get in the laboratory, and then 3 months later, they fired me. So obviously something was going on. I purchased a piece of equipment that allowed 2 systems to talk to each other. It cost $32,000. So when the budget came in to pay for that, they didn't have enough money in the budget to pay for that allotted. So I was the head of the lab, so I was fired.
It had to do with the purchase of ammunition from Ed's Pawn Shop, right?
No, that's the integration is what I got fired for. I also purchased ammunition from Ed's Pawn Shop, but I didn't follow the chain that I was supposed to follow.
That was one of the concerns, and you also had a matter where you requested payment for a File on Q Incorporated without following the purchasing protocol. Is that correct, sir?
That's the integration, yes, sir.
But in addition to what they labeled as illegal purchases and reckless disregard for following those procedures, they also indicated you lacked the maturity and skill set to be trusted as a criminalist manager of the crime lab. Is that right?
That's what they listed.
And that's when you basically went about your decision. You're basically going in to business on your own. Is that correct, sir?
Yes, sir.
And basically, it's really since then that you've been primarily testifying on behalf of the defendants. Is that correct, sir?
I would say primarily.
Yes, sir. And in fact, when you were at the crime lab, you had a number of matters too that came up. Is that correct, sir?
Yes, sir.
And there was one occasion in 2001 when you were basically firing a particular weapon, or working with a weapon, excuse me, and you shot yourself in your own hand. Isn't that correct, sir?
Yes, sir.
And in fact, in 2000 as well, in 2000 while you were at the crime lab, there was a matter as well where you basically violated the GBI policy in regard to the use of computer hardware and software. Is that correct, sir?
Yes, sir. We use each other's passwords. Yes.
Well, that was a matter where you were suspended for doing that. Is that
I
correct,
haven't
sir?
even seen this. I don't recall seeing this. Could I see what it is? Because it's totally violating the civil discovery.
No, it was not. It has all been provided to the
Well, I
defendant.
don't recall seeing that.
I recall it the other day.
Well, I don't recall it. Is that what you told me? That he
No,
couldn't
no,
talk from
this-
and you let him do it? You recall that, young?
Have a seat, sir.
Do you recall that? You said it for the record that he couldn't use, but you let him use it. That's what you said out your own mouth.
Continue.
And I want to object, you bias and prejudice is a violation of the county code. If I know this him, I want to let you be my judge, for the record.
Continue.
Sir, at that time, there was a matter where basically they felt that you jeopardized the security of the system there, the computer system, by accessing certain matter and basically changing the assignment of cases from one agent to the next. Isn't that correct, sir?
Correct.
Okay. And you were suspended for that, were you not?
I was.
And you were suspended for how long, sir?
I think it was 2 weeks, but that was 2000, so I think it was 2 weeks.
Yes, sir. And in fact, in October of 2000, you also had an official reprimand as well for something involving an absolutely incorrect report concerning muzzle and target distance and gunshot residue, right?
And then I corrected it before I went to court. That's correct.
You'd issued a report by looking at a piece of clothing, and you basically indicated at that time that it basically was the muzzle to target distance the distance from the end of the barrel there to the piece of clothing there was 1 inch. Isn't that right?
Correct.
Then you looked at the autopsy photos later, and you came into a different conclusion, saying that basically the muzzle to target distance would be approximately 3 feet or greater. Isn't that right?
That's correct.
And when you looked at that piece of clothing, as it turned out, that was of clothing of a homeless person, right?
Correct.
And that clothing was dirty and everything, right?
Correct.
And you took basically that dirt and those kind of things as if to be that was some sort of powder or something. Isn't that right?
Correct. That was one of the first cases that I had ever worked. I started in '98. So I was pressured by the police to give an answer. I didn't get the autopsy report like I was supposed to. I just tried to go off the clothes. So that was a good lesson. I got the autopsy report. I corrected the report before I went to court. So I corrected my wrong. And I
Sir,
learned.
you went to work for the crime lab in July of 1998, right?
Yes.
And you issued the results about that 1 inch muzzle to target distance, pretty much almost a contact wound, on August 31st of 2000, correct?
Correct.
About a little more than 2 years after you started working with the crime lab, isn't that right?
But I had to go through a year and a half of training, almost 2 years. So that was one of my first cases that I ever worked. So that's correct.
And you were basically issued an official reprimand by the crime lab for that, were you not?
I was.
And that had to do with the muzzle target on clothing, right?
Correct.
Now, you said you did that because you felt pressured in some way, that would somehow affect how you did your work, is that correct?
I was pressured to get the result back right away, so I just did it without the autopsy report because it wasn't ready at the time. So I tried to give the police an answer right away. I learned from my mistakes.
Yes. Now, let's talk about Tony Howard's clothing, if you can. Is that right?
Yes, sir.
Now, earlier you talked about how you requested photos of Tony Howard, didn't you?
Yes.
I object, Judge. That didn't leave, he requested, I asked. He didn't request it, it was me the one requested.
Sustained.
Judge, he requested photos, regardless of who he requested of, he requested photos.
If you will identify who requested them from.
You made a request for photos from the defendant, right?
I did.
And at no time did you ever request to look at that uniform of Tony Howard, did you?
What would be the clothing? What are you talking about?
The uniform of Tony Howard, the shirt.
That's correct.
You never requested to look at that, right?
No, sir, I did not.
And you reviewed this whole case, and you knew that that was in evidence, didn't you?
That's correct.
And if this was so critical, at no time did you ever request that, did you?
That's correct.
And you understood Kyle Felix was subpoenaed not only by the state, but also by the defendant, didn't you?
Yes.
And you understood he was never requested to do that work either, was he?
Correct.
By the defendant. You understood that, right?
Correct.
And if that was so critical, you certainly would have requested that. Isn't that fair to say?
No, sir, I was not asked to perform that test.
Well, I understand that you've indicated how important that was to get done, right?
I think it'd be more critical to look at the pictures of the skin than the shirt. The more a shirt is handled, you can lose powder, you can lose things from clothing, but your skin is your skin. So your pictures of your skin would have been a much more accurate indication of the range.
Didn't you indicate, though, about the uniform that you needed to look at that you thought it strange that they didn't look at those clothes?
I think it's strange they did not look at them. They were the crime lab, that's
Well,
correct.
it was strange for you not to request those too, wasn't it?
No, sir, I looked at the pictures of the clothing, but I was not asked to perform any chemical tests.
You looked at the pictures of Tony Howard's clothing. That's what you're telling us?
I did.
There are no pictures of Tony Howard's clothing. Don't you realize that? It was in the bag? Don't you realize that?
Objection.
There are, they provided pictures of the clothing. Everything they got was stuff I got. he the one put the picture, everything they took pictures of, I got them, all the CDs, I got them, all the paperwork, they got it. I guess he want these little ugly lies he telling.
Understand?
I stand corrected, so you saw pictures of,
Sustain the objection.
you saw pictures of Tony Howard's clothing?
Yes, sir, I believe so.
So you knew that was available, right?
Yes, sir.
And you knew enough to ask for pictures of Tony Howard, right?
I object to it, ask and answer.
Sustain.
This is you didn't ask for pictures of the clothing, right, did you?
No, sir.
And one of the reasons you didn't, as you started to say here, the clothing had been handled a good bit, isn't that correct?
Correct.
And you understood that he had been shot critically there at the scene, didn't you?
Correct.
And you understood that EMTs were working on him at the scene, don't you?
Correct.
And you understood they had to take his and tear his clothing off and cut his clothing off in order to try to make sure
I
they saved his life. Isn't that
He wasn't
correct?
there what EMF was doing. He didn't have an idea what they were doing there. That's speculation. He wasn't there.
He's testified to him reviewing all of this information, everything that's provided in reciprocal discovery, and he's basically offered some opinions.
I withdraw the objection.
Correct.
You knew that was done, right?
Yes.
You understand they were doing that to try to save his life, right there. You understood that?
Yes, sir.
And you understand that was the primary concern for the EMS personnel or other people from the police department, right?
Absolutely.
And that he basically was transported to the hospital, right?
Yes, sir.
And you understood that the purpose of the hospital was try to make sure that they saved his life. Don't you agree with that?
Yes, sir.
That was the primary purpose above everything, right?
Absolutely.
And you understood that his clothing was was off of him and in a corner on the ground, wouldn't you?
Yes, sir.
And as you've indicated, the one reason you may not have requested that, because you knew the clothing had basically
I
been
object to
taken.
ask and answer. He didn't already ask and answer.
He has not been asked and answered about the reason why he did not make that request.
I was not asked to perform that test, so I did not get the clothing. Also, in order to perform that test,
Mr. Roberts,
Let him finish
let me
his
ask
answer, Your Honor. He hasn't
you-
finished his answer. Let him finish his answer. Like he did.
I will allow him to finish his answer.
also when I perform these chemical tests, I'm an individual. I can't
I
perform.
would respect that that's not responsive to the question I asked you.
Yeah.
I didn't even finish my question
I-
for him to be able to answer that. That was not responsive. I didn't get a chance to finish my question.
Have a seat. I'm gonna let you finish your answer. Follow it up.
Thank you, Judge.
I can't perform the chemical test because I don't have the chemicals necessary. You have to have certain licenses in order to obtain these chemicals. That vaporous lead testing, you have to have sodium rhodesonate, you have to have hydrochloric acid, you have to have a number of chemicals that I don't have at my presence. So I could have requested the shirt, but I cannot perform the chemical testing.
But that testing could have been done, right?
It sure could have by the
Yeah.
crime lab.
But what you indicated, though, the reason that where you decided to request photos of Tony Howard was because of that shirt had been handled in many different matters,
I
right?
said again, Judge, he asked and answered it.
Sustain.
He has not answered that question.
I sustain the objection.
So when something's handled like that, right, particles like that really start to fall off and no longer available, and therefore any test that could be done would be pointless, correct?
Not the chemical testing, but the visual, yes, sir.
Well, you indicated just a minute ago about the clothing, that basically what happens is the particles and all those kind of things go off the clothing, right?
Not all of them, depending on the range of fire, but some could be lost.
That's right. Let's talk about the pictures of Tony Howard. You didn't expect there to have somebody stop there at the scene before he could move from the scene and have somebody take pictures of his face,
I
the head where he was shot. You wouldn't
Speculation,
expect that.
speculation. That's speculation.
You wouldn't expect somebody to stop at everything they're doing and trying to save his life and take pictures of his face, would you?
No.
And when he got to the hospital, you wouldn't expect a doctor to stop following the efforts they have to basically attend to his wounds and stop the bleeding and clean it up and do all of that, and in order to take a picture before they do that. You wouldn't expect that, would you?
I would expect a picture after they did that because the bruising in the skin wouldn't go away. So if his face was shot at close range, I would expect to see him stippling up to several days later, and there were no photographs ever submitted to us.
And you would expect a doctor to take photos there at the hospital? Is that what you're talking about? And then would take off the bandages and basically go ahead and take photos of Tony Howard there at the scene?
No, the
That's
police.
what you'd expect?
The police, yes, sir. Yes, sir, I
You would
would.
expect the police to come in there and interfere in what's going on at that time and what he was doing in order to take pictures of his face?
Yes, sir, that's standard. Yes, sir. Yes, sir.
You're saying that is standard care for a patient who's been shot?
No,
in
it's
the
standard
face?
for an
Is that what you're trying to
investigation.
tell us?
It's standard for an investigation, yes, sir, to take pictures of the wounds, yes.
When somebody is in critical condition in the hospital, you're telling us it's standard care. That's what you're trying to tell us, Mr. Robinson?
To remove a bandage off of a face, it's not going to hurt anything just to take a picture. Yes, sir. It would be very relevant to this case. This is a death penalty case.
Now, you indicated, let me ask you about these ejection patterns that you've talked about, okay? You said you did the ejection patterns on a Smith & Wesson 40 caliber, is that correct?
Yes, sir.
What, this particular weapon or a box?
It was.
And you basically did that in regard to what you had to say by indicating that you had the weapon at shoulder height, right?
Correct.
And it was pointed in this manner straight ahead, isn't that correct?
That's correct.
With your wrist locked and pointed straight ahead to make sure the weapon was pointed straight ahead, is that correct?
Correct.
And you're how tall, sir?
6 feet.
And you're talking about, when you're talking about an ejection pattern and how far something would eject, you're not talking about, let me strike that. When you do that, that assumes the weapon is basically in the position that you had it in when you actually fired the weapon. Isn't that right?
That's
During your
correct.
test,
That's correct. Yeah, it's a scientific way of doing it, normal fashion.
And you indicated that somebody who's 6 feet high, who basically has the weapon at shoulder height, that it would, the casings wound up landing 6 feet 5 inches back into the right. Is that right?
Yes, sir.
And you were basically, when you were doing that, did you turn around and look exactly where that landed? Is that what you did?
I had someone mark them for me, yes, sir.
By the visual of where they saw it actually hit the ground, right?
Correct.
And it's not where they wound up after it hit the ground, was it?
That's correct.
In fact, as far as just in that manner, if somebody's holding it at shoulder height, your height was 6 feet, right? If they're doing that, it could actually hit the ground and bounce in many different directions depending on how that particular casing hit the ground, right?
Sure.
And it actually depends on the surface that it hits too, does it not?
Absolutely.
If it basically hits in the grass, it may be likely to stay in the grass, right?
Correct.
If it's on the concrete, it might actually bounce perhaps farther one way or another. Isn't that right?
Correct.
So you don't have any opinion about where those casings wind up landing, do you? After it hits the ground. Where it winds up bouncing to.
I mean, it gives you the proximity, like we talked about before, about where the shooter was. There's no way that cartridge case is inside that car unless the gun's inside the window.
No, that's not responsive. That's not responsive to my question.
He asking him for the ejection pattern where it hit that, so he can answer the question any way he want to answer.
That's another question.
I'm talking about in your test findings, right? If it basically hits at your height, within its shoulder height, if it basically hits, it hits the ground at 6 feet 5 inches as a general rule, right?
Correct.
But sometimes it was not 6 feet 5, sometimes it was a little bit closer, sometimes it's a little bit farther, isn't that right?
Correct. But you said where they bounced to. In this case, they were all pretty close to
Mr.
right
Robinson,
around that area.
I told you, I'm not asking you about the scene right now, okay?
Okay.
We're gonna get there in just a minute. Now, if you were 6 feet 5 inches and somebody's holding it at shoulder height, it would actually go farther than 6 feet 5 inches, wouldn't it?
Not really, it's relative at that distance. If I hold it down at waist high, up to here, up to here, up to
I
here.
would object that he
it-
approach
it's-
the witness.
Can I ask you to step back, because so we can pick things up, please? Yes, Mr. Hood?
I need to demonstrate this while I'm doing it.
Can you do it from there? What would you say?
You got it.
I didn't ask you about moving it up and down. I'm talking about if somebody's standing at shoulder height and they're 6 feet 5 inches, and that casing comes out of the weapon,
Yes, sir.
right? It's gonna come out from a higher point than somebody who's 6 feet tall, right?
That's correct, but that's what you're asking me. It's still gonna hit about 6 feet 5 inches away. It doesn't matter if it's shoulder high, it doesn't matter how tall you are, it doesn't matter if I hold it at waist high, it's still about the same thing. 6 feet 5 inches at a 45-degree angle. It doesn't matter about the height, because we've tried that, we've tested that at waist high, shoulder height. Now, if I shoot it on the ground, sure, but from waist up, it doesn't matter 6 feet, 5'11", 5'10", or 6'6". It doesn't matter. It's still about 6 feet 5 inches away, approximately 6 to 8 feet.
Mr. Roberts, you remember me talking to the hall just here yesterday? You remember me talking to you about that?
Yes, sir.
And you remember me telling you that, hey, if somebody's 6 feet 5 inches, that casing's gonna wind up hitting the ground further out than it would if somebody's like 5.5 feet?
I mean, it's still relative.
Isn't that correct?
Yes.
Yes. And the reason would be because if somebody's taller, it's gonna start from a higher spot, and therefore it'll go further before it hits the ground. Isn't that correct?
It's still relative. It's still about 6 feet away, 6 to 8 feet.
That just violates all principles of physics, does it not, Mr. Roberts?
No, sir. I've
And
shot
common sense.
thousands of guns. I've shot different heights. It's about 6 to 8 feet away.
6 to 8 feet.
Yes, sir.
Well, you said 6 feet 5
Well,
inches.
when you want to talk about
before.
Smith & Wessons on a 40 caliber just like this, I've shot hundreds of them. It's about 6 feet away. It doesn't matter what position the gun's held in.
Well, wait a minute. You just said a minute ago 6 to 8 feet.
With all guns, 6 to 8 feet. But with
Yeah.
this gun, if you want to talk to this gun in particular, it's 6 feet, and I shot this gun actually 6 feet 5 inches.
Now, let me ask you this. That assumes the shooter basically has it at shoulder height, right?
Correct.
And it's in this particular position, isn't that correct?
Yes, sir.
Sure, that's speculation. He don't know what I had it going at.
Your Honor?
But it's still speculation, ain't it misleading?
It's not speculation, I will move the objection.
How far was the gun off the ground when you had it at shoulder height, sir? Did you measure that?
I think it's about 5'6" to 5'7".
Did you measure that?
No, sir, I didn't.
And so, if in fact that particular weapon is turned, the wrist is turned, at the time it's fired, even if it's kept parallel to the ground, it's going to eject, it'll eject back into the right from the muzzle, but it actually will go in a further away from the particular person that's shooting. Isn't that correct?
It won't change the distance that it ejects it.
I didn't ask you about the distance.
Okay? You
It
said
would
further.
basically change the
Further means
direction of where it's
distance.
going, right?
I don't understand you when you say further means distance. You understand that?
It would basically change the direction in which it's going, right?
Yes, sir. Yes, sir. Yes, sir.
And in fact, if somebody basically had it where they're pointing it up, it would basically not go 6 feet 8 inches, would it?
That's true.
And if in fact they actually turn it in a manner to where the gun is turned, as I'm showing you this way, where it's kind of where the whole gun is pretty much parallel with the ground and not in the normal position, the ejection, where the port there, would actually be facing the top. Isn't that right?
Correct.
And if they're doing that, it would not go back to the right. If they're holding it like this, it could very well go over their head, right?
Correct.
And that could change all those factors, right?
Yes, sir.
So it really depends on how the gun is being held and where it's being held as to where that casing actually hits the ground or whatever at a particular point. Isn't that right?
That's true.
In addition, sir, where a particular casing is at a particular scene the time you saw it doesn't necessarily tell you where the shooter was, does it?
That's correct.
And that's because there are a lot of different factors that come into play before that casing wound up at the spot it was discovered at the time it was recovered. Isn't that right?
That's correct.
And one of those factors had to be with how it would bounce and how it actually hit the ground, because it very well could have bounced in one direction and maybe bounced in a different direction depending on how that cartridge actually hit the ground, right?
That's correct.
It's kind of like a football that's kicked. If it winds up landing on its point, it may wind up bouncing one way and it may wind up bouncing another way, right?
Correct.
And that's the way it is with a cartridge case too, isn't it?
Yes, sir.
And in fact, if the ground is not flat, it's slanted, that could very well affect where that cartridge case winds up after it strikes the ground to begin with. Isn't that right?
Sure.
Weather could very well affect how the casing wound up, right?
Correct.
Somebody coming into the scene and actually walking through the scene or working on somebody at a particular scene because they've been shot, that very well could affect it, right?
Correct.
Somebody could have kicked it to a different location, right?
Sure.
And so basically where it's recovered from won't necessarily tell you anything unless you know whether or not there was nothing that happened intervening. Isn't that right?
Correct.
So you would have to assume that nothing happened. Nothing happened to it from the point it was ejected until it was recovered, would you? You would have to assume that in order to say, this is where the shooter was, right?
Well, and what I do is when you're given statements, you see if the statements line up with the forensic evidence that you see at a scene. With respect to Mr. Howard's vehicle, the statements that I've been given, they line up exactly with the statements given by Mr. Hood of where he was positioned and how the shooting occurred.
Well, Mr. Robinson, my question was this. In order to be able to say that if the casing was recovered, for you to be able to say where the shooter may have been really depends on there's no intervening factors in between time that may have moved that casing. Isn't that correct?
That's exactly right.
That was my question, wasn't it?
Sure.
Talk about Officer Howard's car.
Let me tell the jury, we're continuing to have problems with various systems back and forth, so it's just necessary to use this both sides right now.
You indicated the casing was right there. Isn't that correct, sir?
Yes, sir.
That's Stacy did at 220. Stacy did at 218. And that photo right there, you indicated the casing was right there, almost next to that left rear tire. Isn't that right?
Yes, sir.
And you indicated that basically the ejection pattern for a Smith & Wesson .40 caliber is back and to the right. 6 feet 5 inches or so. Isn't that correct?
Correct.
And you indicated on direct examination, in order for it to wind up there, the gun would have been pointed toward the front of the vehicle. Isn't that correct?
Correct.
You understood, Officer Howard, both of his shots were from the side of him. Don't you realize that?
No, sir, I did not understand that.
There was a shot basically on the left side of his neck, wasn't there?
Correct.
And there was a shot in his left shoulder that went left to right and lodged in his right shoulder. Isn't that correct?
Correct.
And you understood it went through his driver's side window, did it not?
Correct.
And in order for that ejection pattern, somebody would have to be pointing in this way toward this truck over here. Isn't that right? in order for it to wind up right there.
Correct. The statements are that Officer Howard came through his window, so he's leaning out of his window, so pointing forward would not be any stretch of the imagination when you're shooting forward like that. So it would absolutely line up with that shot, with the cartridge case ending up at the back of the tire, like there it is.
So you would have some idea, as he's reaching out of this window here, that somehow that shot would go left to right. He'd be able to reach out enough. That's what you're telling us?
Left to right. Left to right. Correct.
That particular piece there, you can't tell us what happened from the time that shot was fired until which time that casing wound up there, can you?
No, I cannot.
You understood he was being worked on a good bit outside of that driver's door. Don't you realize that?
Yes, sir.
And that people were going over there back and forth that whole time, don't you?
Yes, sir.
Now, you indicated earlier in regard to Buddy Christian's car, in order for those casings to basically be so close, it must have bounced off the defendant, right?
Yes, sir. I would say that would be the way that the weapon was held. Correct.
And in regard to Tony Howard, you indicated that casing that was in the front driver's seat indicated the weapon had to be inside the vehicle, right?
That's what yes, sir.
But it'd be just as consistent with a casing coming out and bouncing off the defendant's clothing. That would be consistent too, would it not?
No, sir.
I object to him in his lead, because he know Officer Howard testified he didn't grab me. His own witness stated he grabbed me through that car window with him sitting in that car. And then match up what he telling everybody, what I've been telling everybody for 4.5 years.
Your Honor, that's not an objection.
Repeat
That
it.
casing that's inside this particular vehicle, you don't know whether that's where it was landed, do you? You don't know where it landed inside that vehicle, do you?
I mean, it landed in the seat of that vehicle.
Well, Officer Howard was sitting in the vehicle at the time the shots were fired. Isn't that correct, Mr.
Correct.
Robinson?
Correct.
So it did not land in this particular spot on the seat, did it?
That's correct.
Then why did you just testify to that,
Your
sir?
Honor, Tony Howard stated he grabbed me. That's how it
Your
got
Honor,
the seat.
that is
You
not
come
an
out the
objection.
window, you ain't sitting down. You walk out the window. He ain't sitting there. He out like this
That's
here.
not a basis for an objection.
But it's still misleading, because he's trying to make it seem like he was sitting in that car when he done told y'all he didn't grab his act.
It's overruled.
You understood he was sitting in that car at the time the shot was fired. Isn't that correct, sir?
Correct.
And you understood that basically after it was shot, that he basically came out of that vehicle, opened the door, and came out and laid down on the ground. You know that too, don't you?
That is correct.
And so you're not telling us that the casing that was found right here on that particular seat was exactly where it was after it was fired, are you?
No, I'm not.
And you understood from all the reports you had, you understood that, did you not?
I did.
That Officer Howard indicated that he first felt, the first shot he felt was basically upside his face. Don't you remember that?
I do.
And that he felt basically what happened was he felt like he was punched in the face. Isn't that correct?
Correct.
And that he didn't feel a shot in the shoulder. Isn't that right?
Okay.
Isn't that correct?
Yes.
What you understood?
Yes.
And it's your belief that the shot that went through his face and neck was the one that wound up lodging, bounced off that traffic book there and bounced into the B-pillar. Isn't that correct?
It had to be because the other one didn't exit.
Now, and the reason they were able to do a trajectory rod here in this photo, because there were 2 points they could match up. Isn't that correct?
Yes, sir.
Is that right?
I guess.
Well,
You don't need 2 points. You just need something to stick the rod into. As long as you have the path of a bullet through a seat, you just place the rod into the seat. So you don't need 2 points to do anything, but they have 2 points in that photograph that you're showing me.
sir, if they'd only had the B pillar, they could have put that rod in the B pillar there and put whatever trajectory one way or another. Isn't that right?
No, sir. You use a cone to take up the space for the bullet hole, so you don't let the rod. It's improper, and officers generally do that. They just stick a rod in the hole and they just make it how they want it. But forensics, you stick a cone shape in the bullet hole so it fits the rod in the center of the hole, so you can tell exactly how the bullet traveled.
But when you do that, it depends on how you fit the cone in there, right?
No, it fits right in the center of the hole, sir. That is the standard operating procedure for forensics when you do this kind of trajectory.
That you just have one hole and you can take a trajectory rod with that. That's what you're telling us, really?
Absolutely. Absolutely.
And in the seat with Buddy Christian, where it had all that foam in there, you're telling me that you could somehow stick a rod in there and be able to tell what the trajectory was by doing that?
Absolutely.
And when you did that, don't you think when the foam is there and you start pushing it through, it's going to basically change the trajectory? Don't you realize
No,
that?
sir, because it would line up with the defects in the glass. So then you would know you were right by placing it into the foam. You don't need the second point. It just validates the second point.
Well, the defects in the glass that you understood was all the glass was broken out, right?
Correct.
As stated in that photograph, right?
Correct.
And you never knew or understood that there were 2 holes in that glass, did you?
I knew there were 2 holes in the glass because there's 2 holes in Officer Christian.
Well, sir, in the photos that you were shown, there weren't 2 holes, were there?
That's correct because the glass is shattered out.
But before it shattered, do you understand that there were 2 holes in the glass at some point? You understood that?
Yes, sir.
And so you understood that glass shattered after that?
I understand that.
When people may have been coming in and out of that
I
particular
understand the
vehicle to check
officer
on Officer
opened the
Christian?
door. I understand the officer opened the door and shattered the glass. Yes, I understand that.
And so when that happens there, you talked about how the glass is shattered, so it must have been pressed up against the glass, right?
That's correct.
Because when you press up against the glass, it had that pressure, and it's going to basically go ahead and shatter the glass, right?
It shattered a great deal because there's glass all across the front of the vehicle. That's correct. That's from gas pressure, not the bullet.
But before that window fell out,
Yes.
there's 2 holes in there, right?
Correct.
And you don't have any idea when somebody closed that door, when that the rest of that window fell out, that other glass may not have found its way inside the vehicle, right?
That's correct. But it would not find its way across to the other side of the vehicle on the floorboard. That's from gas pressure. That's from force.
Well, the same pressure would be caused if somebody's standing back from that glass, isn't that right?
No, sir. A bullet would just penetrate the glass and cause a single small hole. It would not shatter the glass based on the pressure of the force. A .40 caliber travels at 1,000 feet per second or 700 miles per hour. It has a muzzle energy of 400 foot-pounds. That is force that blows out the glass in all directions. A bullet just punches the hole.
That's just your opinion, right?
No, that's fact.
That's the same fact you want to say it in the exhibit. It's on the screen there where that casing is. You know, are you taking as fact that that's where that particular casing landed? You're not doing that, are you?
No, I'm saying that it had to be that the gun had to be angled toward the front of the car to cause the cartridge case to be located there.
Assuming there's no intervening factors, right?
It struck that car and fell down right beside that car. I mean, that's the intervening factor. The ejection port was angled toward that car, which means the gun had to be facing forward. That's what that tells me.
Well, it's just as consistent as somebody kicking it over there, isn't it?
No, sir, I don't think so, because the cartridge case would eject 6 feet 5 inches, so it would be away from the car if he was facing into the vehicle. Such as you're saying, it would be somebody kicked it 6 feet. I think that's highly unlikely.
basically saying that somebody could not have kicked that particular casing? You're actually telling us that?
6 feet. I do not think that's possible. I don't think that's reasonable that somebody's gonna kick it 6 feet. And if these are officers on the scene and they were to kick a cartridge case, I mean, it's a big assumption on my part, but I would expect them to put it back where they kicked it from, so they wouldn't hinder the investigation. But
Mr. Roberts, they're working trying to save the life of Tony Howard. You understood that?
yes, sir.
So basically, they ought to stop what they're doing and put that cartridge case back. That's what you're trying to say?
No, sir. They could put the cartridge case back when they get through, but there are multiple people. You're acting like there's one person at a scene. There were multiple people on that scene. So they could have put the cartridge case back if that's what in fact happened. You're saying that, not me.
Basically, where the EMS arrived, the officers are there, they're going in there, they may not even know where the cartridge case was, or whether they even kicked it. Isn't that correct?
True.
So you would expect them then to put it back to where it may have been that they had no idea.
You could hear it. It's brass. It's going to bounce on that concrete like you're saying. You'd know when you kick the cartridge case. You might not know until you saw it, and then when you kick it, you just put it back where it was.
Now, they said 329. Indicating that those casings where they wound up being recovered indicates that they had to have bounced off the shooter. Is that what you're telling us?
Yes, sir.
It's just as likely that someone could have kicked those cartridge casings as well. Isn't that correct, sir?
No, sir, it's not. There's 2 cartridge cases within about 3 feet of each other. I find that very hard to believe that someone's going to kick them in that fashion.
Folks going in and out of that, really? You're actually saying that?
Yes, and also there are no damage on those cartridge cases when I examined them, that they had any kind, or for the other cartridge cases for that matter, they indicated they had any scratches, like they'd been kicked in any fashion, sir, so I don't think that's the case.
Well, folks can kick a cartridge case without damaging. Would you agree with that?
Generally, you see scratches where someone has, when someone tells you that they kicked a cartridge case at a crime scene, they get ran over, they get stomped on, you can always see marks on a cartridge case. These cartridge cases appear to have no scratches or any kind of imperfections on the brass.
So basically, it's your position, despite the fact that folks are going in and out that driver's door, that those are exact spots where those cartridge cases not only hit the ground, but actually wound up. Isn't that right?
Relatively, yes, sir. Pretty within a few inches, yes, sir.
If in fact the weapon had been held the way you were talking about earlier during your test fires, it would have gone back into the right. Isn't that correct?
Correct.
And it wouldn't have bounced off any clothing, would it?
That's correct.
You know? And in regard to that particular matter, you don't have any way of saying that there were no intervening causes in between time, do you, sir?
No, I do not.
You don't have any way of saying that those cartridge cases, where they were found, was exactly where they were at the time they came to rest after being ejected, do you?
No, I do not.
And you're basing your assumptions off the fact that that's exactly where they remained after being ejected.
Relatively, yes, sir. Yes, sir.
And that there were no intervening causes, right?
Correct.
And you're assuming that they actually bounced off the clothing, bounced off the defendant when they were shot, right?
Yes, sir.
Which would have been different than what they would have happened to Officer Howard's vehicle, right?
Correct.
And in Officer Howard's vehicle, that shot that wound up in the inside could very well have bounced off of him as well, right?
No, sir, I don't think so. I think once it strikes your clothing or your body, it's going to deaden it. It's just going to fall down. It's not going to bounce off of you like it bounces off this wood or bounces off something hard. It's just going to fall straight down. So no, sir, I think it had to be inside the vehicle, inside the window frame.
Well, the fact that the gun is inside the window frame would be an indication that the shooter wanted to make sure they hit what they were shooting. Isn't that correct? That's consistent with that, is it not?
Speculation, Judge.
He's an expert.
Yeah, but he was speculating as far as on making sure.
I'm going to sustain that objection.
Your Honor. We talk about this, looking at the Cadillac, sir. Defense Exhibit 59. Picture of outside the Cadillac there, is it not, sir?
That is?
And of all the photos you took on your iPhone there, you didn't have one photo of any rod coming out that hole, did you?
That's correct.
In fact, in order to basically put any rod in there, you couldn't get the first rod you put through the hole from the inside out, could you?
That's correct.
In fact, you had to try to get a smaller rod, didn't you?
That's correct.
And then you had to get some sort of a wire, like a hanger type object, right?
Correct.
To try to force it through there, isn't that correct?
Correct.
And so basically, with the door panel, you could not actually do that from the inside to the out, could you?
That is correct.
And at no time did you ever were able to put any kind of rod or any kind of object through that hole on the outside from the inside, were you?
That is correct.
Defense Exhibit number 64. You had to have that door panel removed, isn't that right?
Yes, sir.
And at that time, you basically started feeling your way to put that trajectory rod in there, isn't that right?
Correct.
And again, you weren't able to push it all the way through, were you?
That's correct.
Defense Exhibit 61 shows that rod after you removed the door panel and after you tried to push it through, you had it in that direction, right?
That's correct.
In that direction, it looks like it's headed toward the driver's seat, doesn't it?
It does.
Defense Exhibit 62, when you look at that rod, it looks like it's headed kind of more toward the passenger seat, doesn't it?
I mean, it's just misleading from that direction. It's still pointing toward the driver's seat.
This is your picture, isn't it?
Yes, sir.
And this is one of the exhibits you used, right?
Yes, sir.
And just looking at that, doesn't it look like it's headed more toward the passenger seat?
It may look like that to you, but I'm telling you, I took the picture, so it's pointing toward the driver's seat.
You said it's misleading.
It
So in the
is.
picture there, it appears to be doing that, doesn't it?
That's the way that you perceive it.
Well,
I perceive it going toward the driver's seat, but you perceive it going toward the passenger seat. I'm telling you, it's pointing toward the driver's seat.
and where that's positioned, it's positioned like somebody's sitting in the passenger seat and could very well have had that weapon right there, right? In a position for it to go out that door panel, right?
No, sir, because if somebody sat in the passenger seat, fired that hole, there would have been gunpowder, and it would have peppered the plastic inside the vehicle. So I know the shot didn't come from within about 3 feet of that side, because there would have been gunpowder. There would have been peppering of the plastic, the molded plastic.
That's right. It could very well have been somebody sitting in the driver's seat and fired that weapon too, isn't it? That's consistent.
I would say the shot was fired from somewhere in the driver's seat area. Yes, sir.
It could be consistent with somebody being in the driver's seat just accidentally firing that weapon. Isn't that consistent?
I mean, I guess if somebody was reckless enough to fire it, yeah, sure.
Well, that would be consistent, wouldn't it?
Yes, sir. Yes, sir.
And it's consistent with somebody being outside that car and firing into the car too, isn't it?
No, sir, it's not. Because if you track that back, it would have had to go through the driver's seat, through the I-beam right there where the door closes. So it could not have penetrated the I-beam. There's no hole. There's no hole in the driver's seat. So it is not consistent with somebody coming from outside the car. That's not correct.
But there's no way that could have been made that from somebody even with the doors open. That's what you're telling me?
That's correct.
Or somebody reaching the gun in the way you were talking earlier.
Somebody reaching in, as long as the gun's inside the vehicle, in the driver's seat area, to make that defect, not from outside the car.
That's right. If somebody's reaching in, it could have been basically close to the driver's window, right?
I mean, I would say it was, yeah.
And make that defect like that, right?
Sure.
But it would have had to be, in that event, where that particular shell casing would have ejected could have been in a different spot too, right?
No, the gun would have had to have been pointed in that direction and ejected to the right and rear in normal fashion for the cartridge case to end up where it did.
If it had been basically there on the driver's side, right?
Yes, sir.
And somebody basically been reaching into the window right there, you'd indicate it would go back and to the right. Isn't that right?
Correct.
In that event, it'd be more likely to be either outside the vehicle or on the left, on the driver's side, passenger seat in the back, right?
It would be dependent on how far the gun was reached into the vehicle. That's correct.
That's correct. And it depends on what may have happened in between time, right?
Correct.
And is it true that casing that was found in the back seat, you're not in any way saying that the weapon that fired, that caused that defect, was the exact same weapon that left that casing, are you?
There's no way to prove that.
That's right. And you're not saying when that casing wound up in there, are you?
No, sir.
You don't have any way of knowing how that casing wound up in there, do you?
Well, I know from the statements and recordings that Mr. Hood was being robbed of his drugs, several weeks or a couple weeks before Mr. Wray's death. So I just know it's sometime in there when this hole occurred. The firing through the door is consistent with the high point ejection pattern based on the cartridge case being located where it is.
You're basing that on what the defendant told you, apparently, right?
Well,
right?
No, Judon Brooks is his statement of how Mr. Hood was robbed. That's where I'm going off of.
There wasn't any description about that a couple weeks ago. You don't know that, do you?
When it occurred, when you asked me when it occurred, I can tell you when it occurred because Judon Brooks made the statement and I watched the video.
Well, sir, you don't have any idea whether that happened or not, do you? You don't have any idea whether the defendant, quote, was robbed or not, do you?
Well, there's a bullet hole in that door to substantiate that, so I would say yes.
You don't have any idea whether he was robbed or not, right?
That's correct.
And you said that could just as well have been accidentally fired inside that car. Isn't that right?
I would say it's highly unlikely, but it is possible.
Well, it's just as consistent, right? Mr. Robinson?
Sure.
You understood this alleged robbery occurred basically in Atlanta somewhere. You know what you understood?
Yes, sir.
let's talk about casings, firing. We talked yesterday in the hall. There are times when basically you've been firing weapons that casings wind up in your clothing, isn't that correct?
Yes, sir.
And that's not an uncommon occurrence, is it?
No.
You wear goggles to protect your eyes when you're firing weapons to make sure that hits you in the eye, right?
Correct.
In particular, if somebody's wearing loose-fitting clothing and winds up wind up in their clothing, you can just as well remain in that clothing, isn't that right?
Sure.
You know, to take that clothing off and throw it somewhere, that casing can come out and stay where it is, where it came out of the clothing, isn't that right?
Sure.
And that casing that was in the back, where it was there, was embedded in that little seatbelt area, right?
It's fallen down there, yes, sir.
Testified on direct that somehow, it's your opinion that the same gun that was used to make that defect was the one that left that casing. Is
No,
that
sir.
right?
I did not say that.
That's right. You can't say that the same gun that made that defect in that car is the one that left that casing, can you?
I cannot.
You can't say how that casing wound up in the back seat, can you?
I can say it's consistent with the robbery that occurred with the high point because it ejects in that fashion. I can say that it's consistent with the robbery.
It's also consistent with somebody basically taking their clothing off and throwing it in the back seat and that casing wound up on the seat there. Isn't that right?
It's possible.
Well, it's not just possible, it's consistent with that, right?
I mean, I think it's kind of inconsistent that you take your clothes off and the cartridge case is going to hang on your clothes long enough for you to throw it in the back seat, but it's possible. That's all I can say. I mean, I'm not sure how you think a cartridge case, I've never seen a cartridge case stay with someone that long where it'll stay on them from the range. It falls off pretty quickly, but it's possible.
It depends on what kind of clothing it is. Isn't that correct, sir?
I mean, loose. I mean, cops wear BDUs. I mean, it can get hung in any number of surfaces on the officer's clothes over
If
here.
you would, please answer the question if you want to explain it that far.
Your Honor, he didn't have to finish his answer.
He's supposed to answer the question first.
It doesn't matter about the clothes. No, it would not matter about the clothes. I think it would fall out relatively quickly.
If it wound up in the hood of a particular item of clothing, it would stay in that hood, wouldn't it?
It is possible.
It's not just possible, it could very well stay in the hood longer than it would if it was in your collar, isn't that right?
Sure.
If
Sure.
it wound up in your pocket, it could stay in that pocket longer, right?
No, I think you know it's in your pocket.
Well, that's not what I'm saying. You
Yes.
didn't know it would stay in your pocket, wouldn't it?
Yes. Yes.
Mr. Robinson, projectiles that were recovered, one from the body of Tony Howard and one from the body of Ray Christian, and the projectiles recovered from each of their cars. They were fired from that Smith & Wesson .40 caliber, weren't they?
Yes, sir.
And those casings found at the scene, the two in Tony Howard's car and the two in Buddy Christian's car, were fired from that Smith & Wesson .40 caliber, isn't that right?
They were.
And the casing in the back seat of the defendant's car, however it got there, matched up the 6 shell casings that were found at the scene of Omari Wray. Isn't that right?
Yes.
And you understood Omari Wray was shot 7 times, don't you?
Correct.
And you understand they only found 6 shell cases, isn't that correct?
Okay.
Isn't that right?
Yes, sir.
And in your review of all the materials there, did you review the matter involving the recordings of Quentin writing made of the defendant, where he basically said that he shot and killed Omari Wray? Did you review those?
Yes, sir.
And did you wind up reviewing the statements of the hostages there, where the defendant wound up admitting shooting Omari Wray?
Yes, sir.
And you remember in that how he described in detail how it happened? Isn't that right?
That's hearsay, I never said it. So, what are you doing, what relevant do this have with this shell case?
Your Honor, he said he reviewed everything. He's
Okay,
been offered as an
I was
expert.
wrong. Let him just finish. Right on.
You reviewed that too, didn't you?
Yes, sir.
And you saw that basically he described in detail how the crime happened. Isn't that right?
He's saying he, I never said it, it's they say. It ain't what Jamie said, so that misleading. If he can say what the specific individual said that I said, I wouldn't object. But don't say what he said. I never told Mr. Robinson or anybody else I could shot this man, so that's misleading in his wording.
I had the witness on wrong.
It's still misleading.
I was asking the question that I thought I was doing.
Identify who you're referring to.
I was referring to the hostages, wasn't I, sir?
Yes, sir.
You indicated that you reviewed where the hostages basically indicated the defendant wound up telling them while they were being held hostage about how he shot Omari Wray. You saw that, didn't you?
I did.
And you saw the statement of Darius Lanier too, didn't you?
Yes, sir.
You remember that?
I believe so.
What do you remember him saying?
I mean, I can't recall exactly what he said because I've seen so much, but if you want to ask me a question, I mean, I'm not here to testify about somebody else's statement.
Well, you reviewed all those in preparation for your testimony, did you not?
I did.
And you remember that Mr. Lanier talked about how the defendant came to his house at 1 o'clock in the morning on Thursday, March the 24th, while he was out running. You remember that, don't you?
Yes, sir, I believe so.
And he wound up going in there with a gun and talking to him. You remember that?
Yes, sir, I think so.
And you remember telling him, basically saying that the defendant wound up admitting to him that he shot Omari Wray as well? Do you remember that?
You sure that's the statement?
And he indicated that it had to do with the fact that Kenyatta Campbell, he was trying to find Kenyatta Campbell. You remember that too?
Yes, sir.
And Omari Wray wouldn't tell him where Kenyatta Campbell was. You remember that?
Yes, sir.
And Darius Lanier indicated that the defendant told him that he wouldn't tell me, I wound up killing him. You remember that part?
That was the statement, yes, sir.
And you remember the statements when you were talking with the hostages and the others that he wound up saying that if Omari Wray's mama had come out, he'd have shot her too. You remember that part?
I do.
And that casing in the back seat of his car matched the 6 shell casings found from Omari Wray's scene, right?
Correct.
Thank you.
Brief, ain't gonna be too long.
All right, go right ahead.
Ms. Roberts, have I ever told you that I shot Mr. Ray?
No, sir.
No, that's self-serving for him to be able to ask that.
Well, he indicated I shot everybody, why can't I ask him straight up?
I'll allow the question.
Have I ever told you at all times that I shot Mr. Ray?
No, sir.
Did I tell you I was wrong?
You did.
Okay. Did I tell you I shot Officer Christian?
You did.
Did I tell you I shot Officer Howard?
You did.
Now, have you ever testified for Mr. Kenneth Malton?
I have.
When you testified for Mr. Malton, did he bring your record out and try to discredit you in front of the jury?
No, sir.
How many times have you testified for Mr. Malton?
I've testified numerous times for him and the Athens Clarke County, and I've always been declared an expert every time I've testified.
So have he ever tried to, anybody in the Athens Clarke County District Attorney Office ever ask you about your record before they asked you to testify?
No, sir.
Never tried to discredit you at all?
No, sir.
No further question, Your Honor.
Anything else, Mr. Long?
Yes, sir. Robinson. In 2010 is when you were fired from the Atlanta Police Department, City of Atlanta Crime Lab, isn't that right?
Yes,
And you were fired for the reasons that we went over earlier, isn't that correct, sir?
yes. Reportedly. Yes, sir.
That's all I have.
I have no further question at this time, shut the recall.
Thank you.
All right, call transportation. We'll get the transportation here, take y'all back.
Yeah.